I met him about a week and a half ago at a Liberal talk, and I expected there would be talks about where the economy was going in Canada, maybe about the mining industry and how the Liberals would help that. But it was actually talk about the medical marijuana and the marijuana business. So we have a very interesting guest now, speaker. His name is John Conroy, and he's helping change Canadian history. Mr. Conroy, please.
Thank you very much. It's 4 o'clock. In 20 minutes, there'll be something called 420. Do all of you know what that means?
Yeah.
When I started out, we didn't have 420. Most of the people my age, I say, you know about 420? They look at me and they have no idea. I got to appear now a number of years at Hempfest in Seattle, where this huge number of people come together in August and have stages and people talking and bands and so on. And one time I got to be on the stage just before 420, and this huge puff of smoke went up, and the police who are here and there all go like this. And that's been that way for some time in Seattle. So, I've been involved in this issue now going back to the mid-70s. And while I grew up in Africa, my father was a consultant on the growing of tobacco. And the African people, some of them commonly used cannabis. And I'm talking a long time ago. All my father would do would pull up the plant and throw it on the ground, and that was the extent of the enforcement of the cannabis laws back in, I'm talking the 50s and very early 60s. And the sky didn't fall in Africa, and hadn't as far as I know. And anyway, I came back to Canada and was called to the bar in 1972. I was a jock, so before that, so I wasn't that involved in everything in the 60s. It was the early 70s where I became involved. And I'm comparing those days because of what I see here today. In those days, I'd appear in front of a judge in Abbotsford Court who would lecture people on the use of cannabis and would send them to jail for simple possession. And then he'd go down to Sumas, Washington at lunch, having popped a couple of Valium, and have a couple of martinis for lunch. And then he'd come back and he'd lecture people about the use of cannabis and send them off to jail. And so about 1977, I was approached to create something called Normal Canada. We had the permission of the U.S. group that existed at that time, the National Organization for the Reform of the Marijuana Laws. And so I was running a community law office at the time, and so we thought this was the way to create a legal lobby group. And of course, in those days, we had lots of support because people were going to jail. People were being heavily impacted by the cannabis laws. And many of us young lawyers were politicized by what judges were doing and what was happening in relation to cannabis during that time. And in the result, became involved in many, many marijuana cases over the years, leading up to I've done hundreds of regular criminal law marijuana cases, but also acted as counsel for Randy Kane in the Malmo Levine Kane and and Clay cases that were in front of the Supreme Court of Canada in 2003. And so that was a challenge to prohibition of cannabis generally. It was not limited to the medical issue. And ultimately the court ruled that yes, the government can decide what level of harm, or even if there's no harm or no significant risk of harm, they can still criminalize conduct. And it's up to the politicians, it's not up to the courts to do something about it. That they didn't have the jurisdiction to do something about it. Now, I hesitate to get too involved in the law and everything at this time of the day, but I think I have to in order to sort of explain some of the things that have been going on leading up to the recent injunction in the other case. When I started practicing, we didn't have a charter. We had the Canadian Bill of Rights. We were still a parliamentary democracy, and the politicians could do whatever they wanted to. And it was very, very difficult to get the courts to do anything because the Bill of Rights was not part of the Constitution. And that didn't happen until 1982. And so in 1982, a very, very significant event happened in Canadian history. We became a constitutional democracy. We have a constitution that is the supreme law of the land, and we assign the Supreme Court of Canada, or the courts, to be the interpreters of that constitution. And so we finally have something that protects us against emotionally reactive politicians in order to maintain certain basic values and certain basic fundamental freedoms, and most importantly, to have remedies or ways to enforce them. And so once the charter came in 1982, and it's not just citizens of Canada, there are some aspects of the charter that are limited to citizens, involving mobility rights, coming in and out of the country and voting and that sort of thing. But everyone in Canada has the right to life, liberty, and the security of their person, and the right not to be deprived of those rights and freedoms, except in accordance with something called the principles of fundamental justice. So what does that mean? There are numerous examples of principles of fundamental justice that the courts have developed as being fundamental to Canadian values that have evolved over the years. And they involve such things as the government shouldn't do things that are arbitrary. And arbitrariness in the context of what we're here discussing, let me step back and just remind you, at least when I started, the Narcotic Control Act was the law that governed all drugs, essentially. And then it became the Controlled Drugs and Substances Act. And so the current federal criminal law is the Controlled Drugs and Substances Act that covers cannabis and all other drugs. And so the courts have found that the purpose of the Controlled Drugs and Substances Act is twofold. It's not only to protect against or to provide public safety, but also public health. And so if the government passes a law that's inconsistent with public health, it acts arbitrarily. So that's an example of that type of principle. Another principle of fundamental justice is if the government passes legislation that is overbroad, that goes too far, it covers people that it doesn't need to cover. And a third example for our purposes is when they pass a law that has grossly disproportionate effects. And so if the government passes a law that affects your liberty, and it's not limited to your physical liberty, the definition of liberty includes making decisions of fundamental personal importance about yourself and your health and these sorts of things. Or if the government passes legislation that interferes with the security of your person, such as inducing psychological stress within you. These are examples that have arisen out of the cases. Many of you, I'm sure, will remember Morgenthaler, which was the abortion case in which the Supreme Court of Canada ultimately struck down the abortion law because of what it did to women, or caused women to have to do. And in the result, the government didn't legislate again in that area, and that's how abortion essentially became legal. So, moving along back to Canada and cannabis, the Allard case, which is the medical marijuana case where we recently obtained an injunction that has allowed people who had personal production licenses or designated growers for a particular patient are essentially grandfathered. There's some loops or holes in the injunction, and there's appeals pending, but essentially it grandfathers personal production and designated growers pending further order of the court. And the structure or the fundamental basis for this entire case arises out of the principles that I was just telling you about. So your right to liberty includes the right to make decisions of fundamental personal importance. And in the absence of some provision for the use of cannabis for medical purposes, a person whose doctor approves him or her for the use of cannabis is put in a position where they have to choose: do I break the law in order to get my cannabis and go without my medicine? So they're forced to choose between their liberty on one hand and their health on the other. And so the court said, government, you're doing this in a manner that's inconsistent with principles of fundamental justice. You're doing this, you're taking away from people who are approved by their doctors to use this medicine their ability to do so. You're violating their right to liberty, and you're violating their right to the security of their person, and therefore declared that the Controlled Drugs and Substances Act was unconstitutional, and struck down sections 4, 5, and 7, which are possession for the purpose, trafficking, and production. And the convention that exists in constitutional litigation in Canada is that the court then will suspend that declaration of unconstitutionality for a period of time to enable the government to try and fix it up, to try and make the law constitutional without creating havoc as a result of the gap that would otherwise exist if the law didn't continue to apply. And so in the Parker case, back in 2000 actually, Mr. Parker was put in this situation. His doctor approved his medical use of cannabis because he, after many different operations and all the other available medical situation, determined that a couple of puffs of cannabis would stop his seizures, and so his doctor supported him and approved him to use cannabis. He didn't want to do it or buy it from the black market. He didn't want to deal with the black market. He couldn't afford the black market, so he grew his own in his house. And ultimately, he was arrested and charged with growing and possessing. And the first court level judicially stayed, which is like acquitting him of the production count, and went on to grant him an exemption from the law in relation to his possession, and he admitted having given some to friends, so there was some trafficking. That went up to the Ontario Court of Appeal, and the Ontario Court of Appeal said, no, you strike down the law, and you leave it to the government to try and fix it up. And so gave them a year to come back and make the law constitutional, provide a viable constitutional exemption that provided reasonable access by people approved by their doctors to cannabis. And so that led to, first of all, Section 56 exemptions. And for those of you who aren't familiar with that, it's a very broad power that the minister has under the Controlled Drugs and Substances Act to essentially exempt people from the law or any particular drug and so on. And that was the beginning. The supervised injection site here in Vancouver, I was involved as counsel in that case as well. It's a Section 56 exemption. It operates through that type of an exemption. So then that led to the marijuana medical access regulation. So that was the first set of regulations that exempted or provided for exemptions for people medically approved. And those regulations continued on and existed until March 31st of this year. And they were then repealed by something called the Marijuana for Medical Purposes Regulations, the MMPR. And so the government, having created the MMAR as the viable exemption, and having existed for some 13 years, all of a sudden decides to come up with this new proposal, which the question is it a viable exemption? Does it provide reasonable access to medically approved patients? Well, it turns out that about 60% of the approved patients in the program are on disability pensions. They cannot afford $5 a gram. As you may know, some of the licensed producers are offering special programs below that price, but the general range is about $5 to $12 a gram on their web pages and so on. And so there's a large number of people who can't afford to do that. And they tell me that they can afford to produce for 50 cents to $3, depending upon how much outdoor time they can do with their crops, because the major cost is electricity. And so, in addition to the poverty question and the lack of provincial health insurance type program, because it's the province's responsibility to come up with that, you've got all these people who are in that situation, and you also have people who have now for years worked on different strains and found certain strains that work for them and others that don't. And so they've done all of this work, they've spent all of this time creating their own production site and learning how to do this and controlling not only the quality but exactly what type of medicine and so on that they're using. And so the government, by the MMPR, has not just planned, but repealing the MMAR took away their ability to do that. And so the court ruled that, I should say, we brought the action in order to determine that the scope of the right includes the right to produce, as was specified in the Parker case, and as was continued since then, reaffirmed in a case called Murnaugh last year in the Ontario Court of Appeal. So we're trying to establish that the ambit and scope of the right includes the right to personally produce for yourself, and it includes, if you're unable to do so because of your illness or whatever, to have a caregiver do so for you. And I just pause to emphasize the current law includes designated growers, and as a result of our litigation, trying to get the government to expand what existed under the MMAR, ultimately you could have 3 licenses or 4 licenses in one place. It started off, you could only grow for one person. We took the government to court. The court agreed that was too restrictive. The government said you can grow for 2. We used to have 3 licenses in one place. We took them to court. The court said that was too restrictive. The government said you can have 4. So you can see the way that the government would constantly react to these court decisions. But in any event, so our action doesn't really, or never intended to cover designated growers generally. We've always assumed that they would be subsumed by licensed producers. So ours was narrower to cover the personal producer and the caregiver for that patient. But the court has basically grandfathered all personal producers and designated growers that were valid as of September 30th last year, and all persons with authorizations to possess as of the date of the judgment, March 21st. which is puzzling and is one of the reasons for the appeal. A major problem has been people who need to change their addresses, who haven't been able to do so. Because the grandfathering, the injunction essentially grandfathers what's in your current license, and there's no provision for it. So we're trying to figure out ways to do something about that. So I should tell you, so that injunction's in place. The trial now is scheduled for next February 23rd, for 3 weeks. A whole schedule of events has been set out. We'll see what happens if they stay in place. The appeal may create some problems there. But another significant thing happened, I think just this morning. You may know that there are some 200 other cases that were filed in federal court. And they were stayed pending what's known as the Allard case. And Justice Phelan in that court has now reviewed each one of those, and today or yesterday continued the stay for all of those that fit within the Allard injunction, but has allowed those that don't fit to go forward. And I'm trying to ascertain whether that includes change of address cases, because if so, that's a good development. Any of the gaps in the injunction will hopefully, these cases will go forward and deal with those issues rather than the delay that's otherwise going to occur. So, and then there's also a few cases in provincial superior courts across the country. I should explain, I guess, to you the distinction between being in federal court and being in a provincial superior court. And the Smith case is probably the best one to use as an illustration. Smith is the BC case that that takes away the limit to dried marijuana. So if you're in British Columbia, you can use extracts and things other than dried marijuana. If you're anywhere else in the country, you can. Because it's a BC case, it only applies in BC. If you're in federal court, it applies across the country. And so our case does include a claim as well that the new MMPR, which again limits to dried marijuana, is unconstitutional. And then there's the other provision of the 150 grams that you're allowed to possess at any one time, which comes from the MMPR, is being imposed on people that still have the authorizations to possess it. So, the red light is flashing. It's kind of like being in the Supreme Court of Canada when they tell you to sit down. We've heard you. And there's, of course, millions of other things that I could go on about. I just want to caution you in terms of, there's no doubt in my mind that legalization is going to happen. We're on a roll in the right direction. It's the roll in the opposite direction to what occurred back in the early 1900s. And they're not going to undo Colorado and Washington State. I've been practicing as a criminal defense lawyer most of my career, in excess of 40 years now. And I had a case not long ago in which the police officer said that the price has now gone down as low as $900 a pound. And so illegal grow operations are shutting down left, right, and center. The overproduction by some medical marijuana people have created a glut on the market, so there's an oversupply. So the price, supply and demand is operating, and we're about to lead into a panel, I understand, that's going to debate prohibition versus regulation. And so from my financial point of view, the more things they prohibit, the better it is for me as a criminal defense lawyer. And so, my market's disappearing. But prohibition is the single most stupidest policy that anybody could ever develop. You're trying to prevent people from consuming cannabis that has no lethal dose so that people can go out and shoot each other in the black market because they can't resort to peaceful remedies. They can't call the cops. Need I say more?
No.
Thank you.